back.
Good afternoon.
Can we do a round for council just to make sure that everyone is back before I resume the hearing, please?
Do you want to put me on? The AG Canada is all here. Thank you.
Caring Society is all here.
AFN is all here.
Good afternoon. It's Brian Smith from the Commission, and I do see my colleague Jessica Walsh, so the Commission's accounted for. Thank you.
Amnesty International is here. Thank you.
Counsel for Nan is all here.
Perfect. So it looks like everyone is back. Okay. All right, Mr. Justice Fable, would you like me to proceed?
Was Chief Civil Ontario here?
I am here. Sorry, I just had accidentally muted myself on this little microphone thing. So thank you, Your Honor.
I think that was the only one that I was noting that didn't answer. But so we're ready to proceed.
Perfect. This court is now resumed.
Recording in progress.
Thank you, Miigwech, Justice Fable. About to get into the submissions portion of my presentation. And I'm going to do, I've got a general, a general introduction to the submissions, and I'm going to deal with harms to caregivers, parents, and grandparents, and also willful and reckless. And then I'd suggest maybe we have just a little 2-minute break to allow us to shuffle our chairs between Mr. Watke and I, because he'll be taking over after that. So,
thank you very much.
Okay, thank you. So then to begin, in a 90-page compensation decision, which is at 2019 CHRT 39, the panel set out the detailed submissions of the parties, including Canada's, which were very similar to what is in their factum in this court. The panel analyzed every argument made to it from the viewpoint of determining the appropriate remedy within the broad remedial discretion it is afforded under the Act in order to compensate for and reduce the egregious discriminatory acts that it had found in its merits decision and which Canada did not contest in any way. After several written and oral submissions, the tribunal addressed compensation issues and did so as Parliament intended, reasonably with careful attention to its home statute, its remedial discretion, and its expert view of the harms that Canada had caused that must be remedied if it's to fulfill its statutory mandate. The tribunal set out the parties' positions at paragraphs 16 through 93. Its summary of Canada's submissions occupy 31 paragraphs of the reasons from paragraphs 49 to 80. They are very reminiscent of what is argued by Canada before this court. 2 points emerge from this review of these paragraphs. First, any suggestion that Canada was taken by surprise because its position was not properly considered is nonsense. And 2, the tribunal engaged in a fulsome, careful review in its reasons. The tribunal turned to its statutory authority and had relied on the well-established principles that apply to it, and any review of its compensation decision must similarly respect those principles. At paragraph 94, the tribunal referred to the principle that the Act is quasi-constitutional legislation, which means its remedial powers are to be interpreted in a broad and liberal manner, and limitations or exceptions are to be interpreted narrowly. Paragraph 97 refers to the tribunal's broad remedial discretion to craft remedies that are effective in promoting the right being protected and meaningful in vindicating the rights of victims of discrimination. As the Supreme Court of Canada said in the CNR case, which is at paragraph 145 of our factum, it's equally important that the rights enunciated be given their full recognition and effect. We should not search for ways and means to minimize those rights and to enfeeble their proper impact. Canada raises a number of issues in its factum and its submissions. The AFN factum responds to all of these. I will address two of the main issues raised by Canada: harms to caregivers, that is parents and grandparents, and the willful and reckless issue. I adopt the submissions of the Caring Society on both these issues, and more particularly their submissions on the harm to children. Mr. Watke will address the other compensation issues in his submissions. So starting out, harms to caregivers, parents and grandparents. At paragraphs 141 and following, the tribunal addresses the evidence of harm. Again, it's a little late for Canada to be claiming there is no harm to the children and families proven, given the findings in the merits decision and the other decisions that I reviewed above. The tribunal cites the factual finding with which it began its unchallenged decision at paragraph 141, and it's up on the screen. To quote, "This decision concerns children. More precisely, it's about how the past and current child welfare practices in First Nations communities and reserves across Canada have impacted and continue to impact First Nations children, their families, and their communities." Paragraph 145, the tribunal addresses the evidentiary requirements and the principle that the tribunal is master in its own house. It cited the decision in Walden as authority for its broad discretion in terms of admissibility of evidence that would not otherwise be admitted in court. This allows the tribunal to rely on the reports it referred to in its main decision, which Mr. Frater disdainfully referred to as borrowing. It is entirely proper for the tribunal to have done so. For several paragraphs after that, there's a summary of the harm suffered by the children and the conclusion that the tribunal does not need to take up the suggestion that they should be dragged in front of a quasi-judicial hearing to put forward their individual circumstances. The panel had expert evidence on the harm done to First Nation children and families when children are forcibly removed from their homes, families, and communities. There is then about 40 paragraphs summarizing findings of fact uniquely within the province of the tribunal to make concerning the harms to children and families that must be remedied through compensation. The tribunal makes numerous findings of fact, all unchallenged, that it had made regarding the harms done. For example, at paragraphs 153 to 154. And we have a compilation of harms at paragraph 155. And I'd like to go to these at least briefly, because most of these we will have reviewed in the review of the decisions that I have done. So the first passage is a focus on the trauma suffered. Furthermore, these adverse impacts perpetuate the historical disadvantage and the trauma suffered by Aboriginal people. The second passage, the panel acknowledges the suffering of those First Nations children and families who are or have been denied equitable opportunity to remain together or to be reunited in a timely manner. We also recognize that those First Nations children and families who are or have been adversely impacted by the government of Canada's past and current welfare practices on reserve. And then at the bottom of page 141, we have the passage, in fact, the evidence demonstrates adverse effects for many First Nation children and families living on reserves and in the Yukon. At the top of page 142, is the page numbering different?
Yeah, it's only 43.
So 140 is at the top of page 42. As will be seen in the next section, the adverse effects generated by the CFS program, corresponding funding formulas, and other related provincial territorial agreements perpetuate disadvantages historically suffered by First Nations people. And then in the next paragraph, at the bottom of that paragraph, but also that these adverse effects perpetuate historical disadvantages suffered by Aboriginal peoples. A lot of it, of course, refers to the experience of residential schools and the tendency of the child welfare policies, federal child welfare policies, to perpetuate historical disadvantages and ongoing trauma. And then we have in the next passages a reference to the statement of apology, which I read previously. Turning over to the top of page 43. And this is a little bit, no, it's actually the second paragraph on that page. Similar to the residential schools era, today, the fate and future of many First Nations children is still being determined by the government, whether it's through the application of restrictive and inadequate funding or through bilateral agreements with the provinces. And then the paragraph, several paragraphs down from that. Okay, right there. This is a striking example of a system built on colonial views, perpetuating historical harm against Indigenous peoples, and all justified under policy. As I said, I reviewed many of these passages as I was doing the history of the, and reviewing the reasons previously, so I won't go through any of the others. At paragraph 162 of the compensation decision, the tribunal refers to several reports that, as Afra said, went in unchallenged, some of which Canada was part of, attesting to the adverse impacts of the children. With respect to 166 to 167 and the compensation decision, Mr. Frater questions the reference to the Supreme Court of Canada case of New Brunswick versus GJ because it is referred to in the Wendy report. But if you look at the case, paragraph 61 of that decision stands for the proposition that the removal of a child from a parent's custody affects the individual dignity of the parent. Paragraph 61 of that decision says, I have little doubt that state removal of a child from parental custody pursuant to the state's parents' patriae jurisdiction constitutes a serious interference with the psychological integrity of the parent. Because of the obvious distress arising from the loss of companionship of the child, direct state interference with the parent-child relationship through a procedure in which the relationship is subject to state inspection and review is a gross intrusion and to a private and intimate sphere. Further, the parent is often stigmatized as unfit when relieved of custody, as an individual status as a parent is often fundamental to personal identity. The stigma and distress resulting from a loss of parental status is a particularly serious consequence of the state's conduct. Also, as the evidence of in the tribunal record, the panel referred to the affidavit of TRC Commissioner Marie Wilson, which I referred to previously, wherein she said she heard from hundreds of parents about the harms caused by the rupture of families and homes. At paragraphs 195 to 196, the tribunal makes reference to its duty to interpret domestic law in conformity with Canada's international obligations. As noted at paragraphs 171 to 180 of our factum, these include the obligations in the UN Declaration on the Rights of Indigenous People, which Canada is implementing. Article 7 says First Nations have the collective right not to be subjected to forced removal of their children. Article 8, First Nations have the right not to be subjected to forced assimilation or destruction of their culture. I also want to refer you to a recent decision of the BC Human Rights Tribunal, a case called Campbell and Vancouver Police Board. This was sent, wasn't part of our compendium, but it was sent last night by email to everybody and to you, to your office, Justice Fable. Well, this case is not binding. It is a good case on anti-Indigenous racism by public authorities and indicates the reasonableness of the tribunal's award in the present case. It's worth mentioning it because it involves a parent. Its facts are very different from ours, but the contrast, a 20-minute confrontation with police that prevented a mother from caring for her son, suggests the tribunal's decision to order $20,000 per caregiver in the present case is not out of line. The case involves an Indigenous mother whose 19-year-old son was arrested by the Vancouver police while she was walking her dog nearby. Discrimination lay in roughly blocking her from getting close to the confrontation and witnessing the arrest. The entire incident took about 20 minutes. The tribunal recognizes the troubled history of relationships between First Nations people and the police and takes notice of the social context that is well documented. The tribunal also accepts that the mother's Indigenous identity was a factor in the police officer's treatment of her, and that her Indigenous background caused her to be fearful of police and also very protective of her son's interest. In discussing the social context, the adjudicator says this at paragraph 113. At the same time, and not unrelated, many Indigenous people have cause to fear any state intervention involving their children. For over 100 years, Indigenous people had their children forcibly removed, often by a police officer, and taken to residential schools where they suffered physical, sexual, and emotional abuse. This overlapped with the 60s scoop, a period in which apprehension of Indigenous children by child welfare organizations dramatically increased. Those children were taken from their parents and their communities and placed in predominantly non-Indigenous homes, often far away, severing ties to their culture and identity. Today, Indigenous children remain alarmingly overrepresented in the child welfare system. In short, the Canadian state has historically and persistently interfered with the ability of Indigenous parents to ensure their children's safety. Indigenous parents have good reason to be fearful when they perceive their children at risk of harm at the hands of the state. At paragraphs 150 to 162, the adjudicator assesses her award for injury to dignity and self-respect at $20,000. There's no maximum in BC. and the tribunal reviews other cases, principally involving racist confrontations with police, and notes the short duration of the confrontation as one of the factors. That is to be contrasted with the potential duration of the separation of caregivers in a present case, which is often permanent and potentially more damaging. The tribunal also, in this case, awards a systemic remedy in addition to the individual remedy of compensation. I want to move to the willful and reckless issue. At paragraph 231 of the compensation decision, which is on the screen.
Mr. Nalgavo, before we leave this topic of caregivers, so I know we heard from the Caring Society in terms of the focus and many of the passages of the tribunal related to children. So and some of the evidence, it refers, and some of the findings rather of the tribunal refer to First Nations children and families. So is that and along with the expert reports and some of the additional reports, is that where the caregivers get become prominent as well as the children? Is that, I'm just trying to understand where the linkages happen.
Yes, that's correct, Justice Fable.
Okay.
Yeah, well, the tribunal in its reasons often doesn't say parents or it doesn't say parents or grand, it refers to families more broadly. So that you're correct. So then moving to the willful and reckless issue, and we've got paragraph 231 up there, where the panel finds that Canada's conduct, and you've heard this several times now, was devoid of caution with little to no regard to the consequences of its behavior towards First Nations children and their families, both in regard to the child welfare program and Jordan's principle. Canada was aware of the discrimination and of some of its serious consequences on the First Nations children and their families. Canada was made aware by the NPR report in 2000, and even more so in 2005 from its participation and knowledge of the Wenday report. Canada did not take sufficient steps to remedy the discrimination until after the tribunal's orders. As the panel already found in previous rulings, Canada focused on financial considerations rather than on the best interest of First Nations children and respecting their human rights. The important evidence given in the merits hearing, Elder Robert Joseph, as I mentioned, said, and I quote, "Let's not make the same mistake twice." And here he's referring clearly to the situation of removal from child welfare. I think this is what the tribunal had in mind when it ordered $20,000 in willful and reckless compensation. In the history of this proceeding described above, I give an indication of the intransigence of the Department of Indian Affairs to the orders of the tribunal. At one point, in obvious exasperation, the tribunal says, "These are not recommendations, these are binding orders." Time and time again, they remind the departmental officials that they need to focus not on their funding formulas, similar to what they did during the residential school era, but on meeting the actual needs of the children and families in the best interests of the child. The tribunal continues to remind the department that the objective is substantive equality, particularly given the historical disadvantage of First Nations children and families. The obvious parallel to the Indian residential schools and what the tribunal calls the old mindset is suggested by the department's preoccupation with per capita formulas during the Indian residential school era rather than the children. The result of that, of course, was the death of hundreds of children, some in unmarked graves, and the creation of broken lives, like Elder Robert Joseph described his life in his testimony. The panel reminds the department that they need to make sure that they don't fall back into old colonialist patterns. We all know the numerous efforts that have been made throughout the years to try and reform the Department of Indian Affairs, which is the oldest government department. Parliamentary committees, royal commissions, auditor general courts, none have been successful. The closest any institution has come to reforming the department is the tribunal, and part of the reason for that has been because the panel has not permitted the department to get away with its usual baffle-gab of excuses for not doing anything, like funding formulas, bureaucratic policies and procedures, and the excuse that the department needs to consult before doing anything, or that it can't do anything without provincial involvement or cooperation. Moreover, the panel's efforts have been firm and sustained, but measured. When departmental officials have been progressive, the panel has not hesitated in commending the department. But overall, in my submission, the tribunal sees the persistence of colonial habits in the department's dark past as continuing to prevail and guiding the hand of the department. This is obviously a major source of concern for the panel. The tribunal has said this case concerns children. It's an urgent situation. So the willful and reckless award in our submission is put forward as a deterrent. If government doesn't want to have to face similar compensation awards again in the future, it must change its systemically racist and fundamentally colonialistic ways. In our submission, given the past conduct of the department and the potential for this conduct to be ongoing, the tribunal's willful and reckless compensation award is not only reasonable, it's absolutely essential if we want to avoid making the same mistake twice. Those are my submissions on harm to caregivers and on willful and reckless. So I will, at this point, Justice Fable, turn it over to my colleague, Mr. Stuart Watke.
Thank you. At the beginning of your submissions, you suggested a short break to get the transition.
Yes.
Would you still like that?
I think that would be appropriate, maybe 5 minutes or 2 minutes even.
Okay, let's reconvene at 5 after the hour. We got 7 minutes.
Okay, be ready.
Okay. See you soon.
Perfect. The court is now in recess.
Recording stopped.
We're going to hear from Mr. Watke.
Yes, I will resume to court.
Recording in progress.
This court is now resumed.
Yes, good afternoon, Justice Fable and my esteemed colleagues. I'm Stuart Watke, General Counsel with the Assembly of First Nations. I would like to begin by acknowledging the words of Elder Sakami, and I also acknowledge the profound impacts of the discovery of the 215 deceased children at the former Kamloops Indian Residential School. In the remaining time, the AFN would like to focus on pretty much 5 points. Dealing with compensations for harms related to Jordan's principles, compensation decision of the tribunal that was reasonable, trying not to duplicate from my colleague, Mr. Nawagabo, Canada's characterization of the compensation order being akin to a class action, procedural fairness, and some systemic versus individual relief. Now, with respect to compensation for harms related to Jordan's principle, starting at paragraphs 211 of the compensation decision, the tribunal addresses harm relating to Jordan's principle. The tribunal notes that Jordan's principle has always been part of the claim of discrimination by the complainants, as set out in the statement of particulars through the presentation of evidence and conclusion with the tribunal's findings and orders. This finding was unchallenged and cannot be revisited at this time. The tribunal noted and found that First Nations children are being denied essential services. The tribunal also heard that extensive evidence that demonstrates that First Nations children were denied essential services after significant and detrimental delay, causing real harm to those children and their parents or grandparents caring for them. However, Canada continues to claim that there was no harm to children and families despite the findings of the merits decision and other decisions reviewed above. Beginning with paragraph 222 of the compensation decision, the tribunal cites the factual findings on Jordan's principle contained in its merits decision. I'll ask my colleague to put it up on the screen. These merits decisions findings include the following. At paragraph 365, the tribunal notes that the 2008 report of the Auditor General at page 16 also found that coordination amongst ANDC or INAC programs, Government Canada programs, and Health Canada is poor. And they note that, for example, it took 9 months for First Nation agency to receive confirmation that $11,000 piece of equipment for child care would be paid by INAC. A 4-year-old First Nations child suffered cardiac arrest. This is a paragraph 366. A 4-year-old First Nations child suffered cardiac arrest and axonic brain injury during a routine dental examination. She became totally dependent on for all activities of daily life. A request was made to Health Canada's non-insured health benefits, a program requesting approval for for medical equipment. However, the equipment was not eligible under the program and required approval of a special exemption. Going on to 369 of the decision, the tribunal notes that there are differences of opinion, authorities, and resources between the two departments that appear to cause gaps in services to children and families resident on reserve. At paragraph 372, the tribunal found that Health Canada's funding for mental health services is for short-term mental health crises, whereas children in care often require ongoing medical health needs. Children in care are not accessing mental health services due to service delays, limited funding, and the time limits of the service. To exacerbate the services for some children, they cannot get the necessary mental health services. They are unable to get access to school-based programs for children with special needs that require an assessment of a diagnosis from a psychologist. At paragraph 381, the tribunal stated that in the panel's view, It is Health Canada's and ANDC's narrow interpretation of Jordan's principle that results in there being no cases meeting the criteria for Jordan's principle. And this is, and also such that an approval defeats the purposes of Jordan's principle and results in service gaps and delays for First Nations children on reserve. And I think this is an important point to note out, that which my colleague from the Caring Society highlighted yesterday. Canada's definition of Jordan's principle at the time was so restrictive, not one Jordan's principle case was actually approved by Canada. At paragraph 382, the tribunal notes, more importantly, Jordan's principle is meant to apply to all First Nations children. There are many other First Nations children without multiple disabilities who require services. Again, in a very restrictive, narrow definition that Canada has imposed on Jordan's principle, it required multiple disabilities, multiple needs for anyone to receive Jordan's principle. At paragraph 381, tribunal noted, in the panel's view, it is Health Canada and ANDC's narrow interpretation of Jordan's principle that results in there being no cases. You might have read that for Jordan's principle. Such an approach defeats the purpose of Jordan's principle and results in service gaps, delays, and denials for First Nation children on reserve. At paragraph 382, they state that, more importantly, Jordan's principle is meant to apply to all First Nations children. At paragraph 458, the panel notes that ANDC's design of the First Nations Child and Family Services Program, along with its corresponding funding formulas and other related provincial territory agreements, have resulted in denials of services and created various adverse impacts for many First Nations children and families living on reserve. The tribunal also addressed this in a decision which I'll just speak to, we won't put up on the screen. And this is in CHRT, 2017 CHRT 7. And this is where the tribunal is responding to NAN's concerns. And I won't get too much involved in this because I know that our colleagues from NAN will be speaking to this more wholesomely. But essentially at paragraph 9 of that, the tribunal noted the Wakapita proposal was left unaddressed by Canada for 7 months, with their reactive response coming only after 2 youths committed suicide. The loss of our, and this is in a letter that the Grand Chief sent Health Canada, he says, the loss of our children by suicide in the Anishinaabe Nation has created untold pain and despair for families, communities, and all of our people. At paragraph 73 of the same decision, the panel notes that the coverage under Jordan's principle was denied because SJ's mother was registered under 6.2 of the Indian Act and could not transmit status to her in light of her second generation cutoff rule. This is another case where service was denied. In this case, the service was denied based on the child not having Indian Act status. The panel continues, the second reason is that it was not deemed urgent by Canada when in fact the situation was not assessed appropriately. Finally, no one seems to have turned their minds to the needs of a child or her best interest. There is no indication that a substantive equality analysis has been employed here. Rather, a bureaucratic approach was applied for denying coverage for children, a child of just over 18 months. Now, Canada's assertion that there is no evidence to support the awarding of compensation for Jordan's principal cases has no merit. The examples relied on by the tribunal clearly above, tribunal which we demonstrated above, clearly provided harm to a child. Federal officials also provide some insight into the harms First Nation children suffered. The tribunal provided the following excerpt as an example. This is at paragraph 224 of the merits decision. And this is in regards to a child who had respiratory problems and needed a specialized bed to breathe properly. And a request was made to Canada to provide this child bed. So the tribunal notes at paragraph 224 of the merits decision. In another case, A child with the Batten disease, a fatal inherited disorder of the nervous system, had to wait 16 months to obtain a hospital bed that would incline at 30 degrees in order for her to alleviate the respiratory distress that resulted from her condition. In our fact, and we refer to this as well, there's a cross-examination exchange between myself and one of the government employees. And essentially questions were posed to the government employee whether or not the bed ordered in 2017 and was delivered in 2018, which approximately took a year, was reasonable. And Ms. Bagley at the time indicated that in responding to a question asked, she's basically was posed to her, my question regarding this matter, considering its child that has a respiratory problem and could face a respiratory failure and distress, how is the length of time between 6 months to a year to provide a child with a bed reasonable in any circumstances? And Ms. Bagley replied, well, from my perspective, no, that's not reasonable. And she goes on to state, but there's not enough information here to determine what were the reasons. Now, if you unpackage this scenario, and it doesn't take a lot to determine the harm here, you have a child that is struggling to breathe on her own. Acquiring an inclined bed would alleviate these severe symptoms and provide a measure of comfort for this child. However, this child suffered for 6 to 9 months to get a medical device she required. Clearly, that child has suffered harm for that 6 to 9 months. Now, if you look at this from a parent's perspective, your beautiful daughter who you love more than anything in life struggles to breathe every day. Because of your own financial circumstances, you can't afford the bed and you have to wait for this service from the government. Every day you see your daughter struggle for each precious breath and you're helpless to do anything. Clearly, as a parent, you are being harmed by the delay in acquiring the services. Now, when you apply this across the board to most First Nation families suffering medical needs, for most First Nation parents in such circumstances, you have two choices under Canada's program. You can either wait for the service and force your child to endure suffering, or you can voluntarily give up your child and place your child in a foster home so that the services can be provided forthwith. Those essentially were the only two options under this program, either under Jordan's principle or a Child and Family Services program at that time. Now, Canada asserts that compensation requires the one to have applied for Jordan's principle. And this was spoken to my friend by the Caring Society yesterday. This is really disingenuous for Canada to ask. At that time, there was no Jordan's principle application, or there was no application process to request a Jordan's principle claim. There was no information to the public that Jordan's principle was available in these circumstances. And finally, the definition was so restrictive that not one Jordan's principle case was approved. Now, my friend from Canada now asserts the tribunal was unreasonable in awarding compensation to parents and grandparents in these cases. It cites a number of reasons, such as Jordan's principle is now not a closed class. The tribunal did not give notice that open-ended compensations was on the table, or no victim provided direct evidence of harm that occurred. The APTN submits that the tribunal gave abundance consideration and evidence before awarding relief to these victims. And my colleague, Mr. Nalgabo, touched upon many of those passages and the decisions related to that. So that deals with the Jordan's principle compensation class. I'll be happy to move on if you don't have any questions.
Just a matter of clarification, Mr. Leckie. I know I'm not sure specifically if the AGC was referring to this in terms of the evolving nature and arguments of that nature, but so the complaint particulars, is it fair to say, just so that I get a good sense of where we're at here, that it's because of the vagueness of the program that at the time of the complaint and at the time of the particulars, it couldn't be specifically outlined as to what the implications or the ramifications of the application of this program was, and it only became evident during the process, so to speak. Is that a fair description? I'm just trying to understand the context better.
I would say that's it's partially right. When it comes to Jordan's principle, keep in mind that Jordan's principle only became a legal concept after Jordan River Anderson. Prior to Mr. Anderson, of course, there were a number of First Nations individuals who required services, but none of them got those services. So it just didn't miraculously start when with Jordan River Anderson. Of course, many First Nations people are grateful to the plight of Jordan River Anderson in bringing this to a national attention. But really, at that time, once Jordan's principle was conceptualized by Parliament through its motion, it really set in motion sort of a definition at the time to ensure that First Nations people would not suffer the same type of harm that young Mr. Anderson faced it, as far as governments, trying to squabble over who has to pay a bill. I think that once Parliament issued its decision on it, or its motion and its definition, it really became incumbent on Canada to start to implement that. And what you hear from the record and what the record shows is that Canada failed to do that. Canada took a very restrictive approach to Jordan's principle. As I mentioned, that you have to have multiple severe disabilities. There are a number of factors that would have to take that a child would have to meet. Essentially, the bar was set so high that not one child that even applied for Jordan's principle was able to access Jordan's principle.
Okay, thank you.
So with respect to the other concerns, now at this point I'll respond to some of Canada's arguments. Now Canada we assert that Canada has failed to show any unreasonableness in the interpretation of compensation under 53(2)(e) and 53(3) of its enabling legislation. Now the APTN contests Canada's assertion that the tribunal compensation is unreasonable. Canada's argument includes a lot of broad brush statements about what the tribunal and the court said. However, a number of these statements are not factually accurate. And moreover, Canada attacks the reasonableness of the tribunal's compensation decision with very little reference to what the tribunal actually said. And my friend, Mr. Nawagalbo, pointed out to a number of paragraphs that actually the tribunal addressed those. So I won't go into a lot of that, but essentially it would be the AFN's position that under the Vavilov framework, reasonableness is a robust form of review, requiring the reviewing court to examine whether the outcome and the reasons justifying the outcome is reasonable. Essentially, as my friend Mr. Nawagalbo pointed out, the reviewing court must begin this inquiry with the reasonableness decision by examining the reasons provided with respectful attention and seeking understanding of the reasoning process followed by the decision maker. At paragraph 85 in the Vavilov decision, a reasonable decision is one that's based on an internally coherent and rational chain of analysis that is justified in relation to the fact and the law. Paragraph 86, reasonableness is considered concerned mostly with the existence of justification, transparency, intelligibility within the decision-making process, as whether the decision falls within a range of possible acceptable outcomes which are defensible in respect of the facts and the law. And at paragraph 91, written reasons given by the administrative tribunal must not be assessed against a standard of perfection. My friend, Mr. Nawagalbo, spoke to a lot of these points. But essentially, what the AFN would submit is that the decision of the compensation decision, especially when you apply it to the overwhelming series of preceding decisions stemming from the merits decision, the decision itself and all the preceding decisions do follow a logical process that's coherent, and it does demonstrate that the decision of the tribunal was reasonable. In its decision, of course, on compensation, the tribunal considered its home statutes, principles of interpretation, and tribunal jurisprudence and the evidence, and made a finding of mixed fact and law that compensation was justified on the record before it. The AFN submits that the Attorney General of Canada's mischaracterizes the compensation award by the tribunal and conflates this premise with comparing it to the type of damages one may obtain in a class action. And at this point, the AFN would submit, to be clear, the tribunal did not order compensation for tort-like damages as Canada asserts it should have. Rather, the human rights awards for pain and suffering under the CHRD, Canadian Human Rights Act, are for compensation for the loss of one's right to be free from discrimination, for the experience of victimization and harm to their dignity. The process employed by the tribunal in awarding compensation was pragmatic. It was consistent with the hallmarks of a well thought out and informed decision. In its line of reasoning, the tribunal first considered the application of its home statutes. From there, the tribunal reviewed the complaint and the statement of particulars. At paragraph 106, the compensation decision, the tribunal notes that furthermore, the statement of particulars of the Caring Society and the AFN from January 29, 2013 requests pain and suffering and special compensation for remedies. At paragraph 108, it's clear from reviewing the complaint statement of particulars that they were seeking compensation from the beginning, and they were also from the start of the hearing on its merits. Now, Canada, of course, takes issue with that, but this is a finding of the tribunal based on its own assessment of the original complaint, the statement of particulars, and the evidence provided before it, that both the AFN and Caring Society were clearly seeking compensation for harmed children and others of Canada's discrimination. And in that request, in that same vein, the tribunal requested the parties to prepare statements of particulars in order to detail a claim that was given to the complaint form. In short, and it cannot be possibly contained. So the statement of particulars, the tribunal notes that the statement of particulars cannot contain all the elements of the claim. It's designed to be short and concise. Now, the tribunal also took into account its own rules and procedures in coming to these decisions. The tribunal also noted that Canada responded to both these compensation allegations in 2013, which demonstrated Canada was aware that the AFN was seeking compensation for pain and suffering and special compensation for individual children. So it completely rebuffs Canada's assertion that it was surprised that the parties were seeking compensation. The tribunal would then conducted a thorough assessment of the parties' positions at the compensation hearing. The tribunal also considered Canada's position on tribunal's so-called inability to award compensation to victims who are not named complainants to the complaint. In this regard, the tribunal stated that there's nothing in the act to suggest that the tribunal lacks jurisdiction and cannot order remedies benefiting victims who are not complainants. The panel disagrees with Canada's argument and interpretation, including Section 40. So in determining that there was no bar to considering an award for compensation, the tribunal actually turned its mind to the pain and suffering analysis. In this regard, the tribunal assessed its home statute as well as the case law. The tribunal once again gave full consideration to the parties' submissions. The tribunal then assessed the evidence of harm to First Nations children and families and noted in the compensation decision that harms were overwhelming. At paragraph 147 of the compensation decision, the tribunal states, children who were unnecessarily removed from their homes will not be vindicated by a system of reform, nor will their parents. And this was spoken to by my friend by the Caring Society. They also note that even if children are unified with their families, they cannot recover the time lost for the families and the loss of opportunity to remain in their homes. The tribunal also reflected on its merits decision, highlighting the evidence of Canada's Child and Family Services program and the discriminatory effects of funding models on the First Nations children and their families, which continue throughout their lives. The tribunal also considered the gravity of breaking up children from their families and communities. The tribunal applied findings from the Supreme Court of Canada, which my friend Mr. Nagwell spoke to, taking judicial notice that removing a child from their parent's custody affects the individual dignity of that parent. In regards to compensation under Section 53 of the Canadian Human Rights Act, the tribunal ordered compensation for $20,000 for willful and reckless behavior, which my colleague Mr. Nagwell spoke to. And there we would repeat that the tribunal found Canada's conduct was devoid of caution with little or no regard to the consequences of its behavior. And that's found at the merits decision at paragraph 231. And in coming to its decision, of course, the tribunal, which my friends pointed to, had reflected on various internal reports, external reports, including National Periodic Review, Wendy, parliamentary reports, over the course of the 20 years highlighted, or the 20 years of this complaint, and highlighted that the program itself was harming children. It made that finding. And really at the heart of the discrimination was a program's perverse incentive. My friend from the Caring Society pointed out that Directive 20-1 had inherent flaws. And when the AFN and Caring Society initially filed their complaints, the only funding mechanism under the First Nation Child and Family Services Program was Directive 20-1. And essentially, while provincial legislation required agencies to look at the best interest of a child and to apprehend as a last resort, those mechanisms were not developed or enabled in Canada's federal program. First of all, Directive 20-1 had no prevention funding whatsoever. So even if an agency wanted to provide a least disruptive measure or to provide an alternative to apprehension, the program just didn't allow it. The funding mechanism wouldn't allow it. First Nation agencies was noted in the NPR was underfunded by 22% compared to other agencies, which is a significant decrease in funding. And also, as my friend Mr. Nabagabo pointed out, funding was provided on a per capita basis, much like Indian residential schools. So much like the Indian residential schools, in order for an agency to get funding, to get sustainable funding, more kids had to be brought into care. And once they were brought into care, Canada would provide them with all the funding they needed for that child and to provide services. And essentially, there were very little restrictions on what money could be used for. As my friend from the Caring Society pointed out, services that were not necessarily available, such as dental work or other type of medical services that voluntary health benefits would not cover, would be covered if a child was put into care. So as pointed out, the Enhanced Prevention Program, which brought in some prevention work, was meant to provide some prevention funding to First Nation agencies. It wasn't rolled out across Canada, but again, the tribunal noted that was insufficient funding was provided for prevention, even when First Nations were given funding for prevention. So in assessing Canada's records, the tribunal found that Canada chose to put its financial interests above First Nations children, and the record contained information where Canada was considering 3 options to address underfunding. And my colleague had pointed out. So this is in Canada's document. It was a PowerPoint called The Way Forward, and my friend from the Caring Society spoke to it. And essentially, it provides 3 various options on how to enhance child welfare programs across Canada. And the first option, of course, at that time was to enhance the EPAFA program, which required a $32 million investment annually. The second option is to fully expand EPAFA, and this is to provide a number of services in there. And again, you can see the amount increases significantly with respect to funds that Canada would have to invest in the program. And the third option was for Canada to get out of the business and leave it up to provinces and territories. And this is where Canada looks at this assessment and said, well, the costs will become so dramatic that they'd be paying a lot more for providing the proper services or equal services the provinces were providing, as opposed to the other two options. As my friend from the Caring Society pointed out, it's unsure of whether I don't think any of these options were adopted by Canada. But what it really demonstrates at that time, Canada was turning its mind to, and knowingly turning its mind, that its programs were deficient and that further investments would have to be made. And clearly that did not happen. And really Canada at that point, which the tribunal made a finding on, was looking at its own financial interests, trying to see how the cheapest way to provide the services, not focusing on the best interest of the child, but really focusing on their bottom dollar, which caused harm to many First Nations children. So the AFN will argue that the process and outcome of the tribunal's decision amply reflects an internally coherent rational chain of analysis. In addition, the tribunal's decision follows from the facts and law reviewed, and the tribunal meaningfully explained why its decision best reflects Parliament's intention. The evidence addressed the despair and suffering experienced by First Nation children, parents and grandparents, and having their families torn apart, as well as statements reflecting comments from hundreds of parents with child taken into custody or care, who emphasized the worst part of removal was the rupture from one's family. And there we would point to, again, to the affidavit of Mary Wilson that was sworn on December 18th, 2016, which is in our compendium. And again, we would reiterate paragraph 9 of that affidavit says, from the parents I heard, the worst day of their life was the day the children were taken from them. That was an Indigenous, that as Indigenous women, they live in fear of having the children taken away. This flows from the fact that, further to Ms. Wilson's statement at paragraph 6, again and again, she heard the worst part of removal was a rupture from family and home, from everything and everyone familiar that they cherished. This rupture was the worst and most universal. It applies equally to parents and caregivers as well as the children. The tribunal also relied on numerous findings of fact in relation to the harms visited upon First Nations parents and caregiver grandparents that had made in its merits decision and 10 subsequent rulings prior to the compensation decision, which were based on the vast amounts of evidence. As noted by the tribunal, the evidence was ample and sufficient to make its finding that each parent or grandparent who had a child unnecessarily removed from their home has suffered. The tribunal's careful and deliberation on this point illustrates in its comments that in light of the record before it, it was forced to limit its compensation to First Nations parents and parents caring for the child, or alternatively their grandparents. In the compensation decision, the tribunal stated at paragraph 185, the evidence is ample and sufficient to make a finding that each parent or grandparent who had one or more children under his or her care, who was unnecessarily removed from their home, family, and community has suffered. Any parent or grandparent, if the parents were not caring for the child, who had one or more children removed from them and later united with them, had suffered during the time of separation. The panel intends to compensate one or both parents who had lost their children removed from them, and if the parents were absent and the children were in the care of one or more grandparents, the grandparents. While the panel does not want to diminish the pain and suffering by other family members, such as other grandparents not caring for the child, siblings, aunts, uncles, and the community, the panel decided, in light of the record before it, to limit compensation to First Nations children and their parents, or if there were no parents caring for the child, their grandparents. At paragraph 186, the panel also recognized that the suffering can continue even when families were reunited, given the gravity of the adverse impacts of breaking family apart in the communities. And this evidence, of course, concerned the First Nation Child and Family Services Program and the associated effects on already historically oppressed First Nation families. The matter before the tribunal concerned the pain and suffering experienced by First Nations grandparents, parents, and children. For these reasons, the tribunal's findings with respect to compensating the parents and caregiving grandparents is clearly reasonable. Its findings were also consistent with the relevant jurisdiction, which established harms to parents, caregivers associated with the removal of children by the state. My friend from Canada yesterday referenced the fact that the tribunal unduly relied on the Wendy reports when it considered the New Brunswick case. And my friend also spoke to the unreasonable reliance on the utilization of this report to fill in the evidentiary gap and context the statement that was ignored by the tribunal. Now, APTN obviously disagrees with that. Although the statement was referred to within the tribunal's decision and was taken into context of the Wendy report and a discussion on the Charter remedies, it does not diminish the veracity of the statement nor the fact that it was a proper consideration for the tribunal. Although a paraphrase, it remains clear that the court in the case number above JG was quite clear that there was very little doubt that the state removal of a child from parental custody pursuant to the state's parental pari jurisdiction constitutes a serious interference with the psychological integrity of the parent. And paragraph 61 of that decision, I'll just speak to it. It basically says, I have little doubt that state removal of children from parental custody pursuant to the state's parental pari jurisdiction constitutes a serious interference with the psychological integrity of the parent. The parent's interest in raising and caring for the child, as Laforet held in BR, that an individual's interest of fundamental importance in their society. Besides the obvious distress arising from the loss of companionship of the child, direct state interference with the parent-child relationship through a procedure in which the relationship is subject to state inspection and review is a gross intrusion into the private and intimate sphere. Further, the parent is often stigmatized as unfit when they're relieved of custody. As an individual status as a parent is often fundamentally personal identity, the stigma and distress resulting from the loss of parental status is particularly serious consequence of the state's conduct. Now, it was quite reasonable for the tribunal to consider jurisprudence from the SEC and also take into context the various reports that were before it in conjunction with the swath of evidence of harms before it in relation to caregivers. For these reasons, again, we would note that the tribunal's decision was reasonable. I'll now turn on to the issue of the class action. So the APTN submits that Canada is erroneously attempting to mischaracterize the tribunal's compensation order as a class action. Canada provides a comparison of the types of damages one would attain in a court proceedings with that of the tribunals. In an attempt to reframe the tribunal's compensation order, Canada argues that the Canadian Human Rights Act does not grant the tribunal the ability to consider complaints of classes in this case, the removed class, the caregiver class, and George's principal class. Canada's submissions then proceed to discuss how the class actions provide a tort-like compensatory damages. The Canada also contends that the class action rules would have achieved better outcomes and eliminate the need for further orders and negotiations that were processed before the tribunal. Now, of course, the AFN disagrees with those statements. Class action process is one avenue, and the AFN is involved with one of them, as my friend from the federal government pointed out. But clearly, the tribunal process and the human rights option is another available option. And prior to filing this human rights claim, the AFN itself had a decision to make, whether to go through representative court action or the Canadian Human Rights Tribunal process. And I do remember at that time, the decision was made to avail itself to the Canadian Human Rights Act. We would argue that Canada's submissions and proceed to discuss how class actions provide tort-like compensatory damages, and again, that it would provide better outcomes. Now, Canada's argument completely misconstrues the actual purposes of the Canadian Human Rights Tribunal and its authority under the Human Rights Act. Canadian Human Rights Act was not designed to address different levels of damages or engage in the assessment of fault-based personal harms. And this point was also discussed by my friend from the Caring Society. Essentially, the tribunal addressed Canada's class action arguments and decision and its efforts to establish a class action as an appropriate fora, while conversely relying on class action criteria to support its position with the tribunal proceedings. And on that note, the tribunal stated at paragraph 2 and 9 of the compensation decision that on one hand, Canada contends that the tribunal is not the right form to deal with class actions. And then on the other hand, it uses some of the class action criteria to support its position that there are no representative of the group of victims before the tribunal. With respect, the Attorney General of Canada cannot have it both ways. Accepting this proposition that the tribunal is not the right forum to address class action in light of the statute requires one to look at what can be done under the statute and not impose on the class action criteria the tribunal process. While it can be useful to look at class action requirements, the rules of statutory, the rules of statute, sorry, I think I messed up. The rules of statutory interpretation require Canada to look at the Canadian Human Rights Act, given the fact that its jurisdiction is derived from it. In addition, the Canadian Human Rights Act is quasi-constitutional in nature, which would supersede any law conflicting with the CHRA. If the CHR is silent on the issue, the tribunal can use a number of useful tools at its disposition. Now, the Assembly First Nation would submit that the tribunal carefully addressed Canada's argument on compensation, on the compensation order, and it does not amount to a class action. Canada also alleges that compensation must be tied to a number of tort-like harms. Again, this was explained by my friend, Mr. Frater. Yesterday, they assert that the current tribunal's compensation decision doesn't differentiate between experiences between children. Canada takes issues like compensation did not address the duration of suffering. Matter of fact, that the same amount of compensation would be awarded to a child removed for 3 days versus someone that's been shuffled between homes for 13 years. In the case of Jordan's principle, it contrasts a parent's surrendering of their child for services versus a child not getting a tutor as quickly as they thought they had. So those were basically the arguments of Canada. And like the Caring Society, the APTN submits that Canada does not truly appreciate the scope and nature of the human rights harms opposed to personal injury harms. We would suggest that the two are very different. The tribunal also fully answered Canada's attempt to divert attention to the class action realm. At paragraph 188 of its decision, the tribunal stated that the Canadian human rights regime is different than that of a court where a class action may be filed. The CHR, the Canadian Human Rights Model, is based on human rights approach that is purposive and liberal and aimed at vindicating the victims of discriminatory practices where considered systemic or not. The tribunal's mandate within it a quasi-constitutional statute with a special legislative regime is to remedy discrimination. This is the first process to employ when deciding issues before it. If the CHRA and the human rights case law are silent, it may be useful to look at other regimes when appropriate. In the present case, the Canadian Human Rights Act and human rights case law voice a possible way forward. The novelty and uncharted territory found in a case should not intimidate human rights decision makers to pioneer a right that is and just path forward for victims, survivors, if supported by the evidence. Now, it is clear that the tribunal did not order compensation for tort-like damages or personal harm, and that's completely appropriate. Compensation under the human rights regime is to compensate one for the attack of their dignity or discrimination they face. In this case, the tribunal made human rights awards for pain and suffering, for loss of right to be free from discrimination, the experience of victimization, and harm to dignity. And that's found in our oral compendium at tab 60. Canada's argument that individual factors and circumstances must be taken into account is not valid within the human rights setting. Rather, the APTN would submit the attack on one's dignity is completely separate than torts. Human rights damages can be better understood in other forms of discrimination, and this is sort of where you can draw analogies. For instance, if you come across a case where a First Nation individual was followed in the store by an employee of that store and detained under a racist assumption that they were shoplifting, it does not matter how long he or she was held, if they were searched or if the authorities were called in cases. The fact that they were singled out in the first place and falsely accused of shoplifting based on their race is the harm. That's the loss of their dignity. Much in the same way with respect to the case before this, it's easy to understand in those circumstances where you see racist acts and it becomes easy to call people out. But in this case, you have children who are being removed from home and they were being targeted because they were First Nation. No other child in Canada was treated the same way. Every other child in Canada had services available to them. They were open to being provided less disruptive measures and prevention type of services. First Nations children were not. They were specifically targeted because they were First Nations. So the AFN would argue that in this case, the tribunal awarded damages for discrimination and deliberate targeting of First Nation child and his or her parent that they were subject to discrimination. A First Nation child suffers indignity through the apprehension or denial of services. With respect to the grandparent, the tribunal found in paragraph 44 of the decision, this is in 2020 C-Chart 15, the purpose of the compensation award by the panel is to compensate the biological parent or grandparent for the loss of a child to a system that targeted them because they were First Nations. That is essentially the harm. It's not, unlike the Canada's argument where they suggest you look at how long they were in care, the circumstance of the care, whether they're abused in care. That's not what the human rights approach looks at. The human rights regime is more inclined to look at what is the discriminatory act. In this case, it is the apprehension of the child. That is the trigger, as well as, in the case of Jordan's principle, being denied or delayed in being provided a service. So the AFN would submit that this Canadian human rights regime, unlike the tort law context, the quantum of compensation awards for harm to an individual's dignity is limited, but is also tied to the seriousness of the psychological impacts and discriminatory practice that it had upon the victims. Canada asserts that the tribunal is imposing a settlement agreement on the parties, namely the Indian Residential School Settlement Agreement. And in this respect, the AFN will argue that's not accurate. The tribunal found that the Indian Residential Settlement Agreement provided a good precedent or a good example of how to conceptualize compensation that the tribunal was making. We would suggest that, so the tribunal can consider the common experience payment under the the Indian Residential School Settlement Agreement and recognize that the experience of living at an Indian residential school had impacted all students that attended these institutions. The CP compensated all former students who attended the schools for emotional abuse suffered, loss of family, loss of culture, etc. That was a good impetus for the tribunal's ordering of compensation. The tribunal noted that all children who were apprehended or were denied later service, as well as their parents or guardians who lost a child to the CFS system or suffered, they all suffered a common harm, and that was the attack on their dignity. Now, yesterday you posed a question to Canada on the nature of the human rights harms. And we note that you asked Canada about what their thoughts were on this tort-like versus human rights type of harm. And we note that Canada did not provide an answer to this question. It merely replied its assertion that the parties were trying to fill in the gaps in the tribunal's reasoning. And the AFN would submit that the answer is telling. Clearly, there's a difference between human rights harms and tort-like harms. And that with respect to the common experience framework, again, the tribunal was looking at how best to shield First Nations children from additional trauma, having to provide evidence of harm. Such a system would provide culturally safe, appropriate process. Essentially, like a CEP application, if you were apprehended, you fill an application saying was apprehended, there's no other evidence, you'd be entitled to your compensation. That process would prevent people, especially young children, some of them who are still children, from coming in testifying about the harms they suffered while being apprehended. Clearly, it's within the human rights regime to award that type of system. It's practical, it's pragmatic, it looks at the best interest of the child. And for those reasons, the tribunal's characterization of that is really appropriate in these circumstances. I'm just looking at the time right now. I don't know if you would like me to break here or just finish off the tort-like discourse before I move on, before we move to a break.
I'm prepared to continue hearing you if you're prepared to continue.
Sure. I'll just finish this section and then we can take a break. So the AFN would submit there are numerous pragmatic reasons why the development of the compensation framework needed to be negotiated. And my friend from the Caring Society took you into the decisions related to the development and some of the background in developing the compensation order. Now, we recognize that compensation for these individuals is complicated and complex. And there are tens of thousands of individuals who've been impacted. So much like the settlement agreement for developing the common experience payment, essentially the tribunal ordered the parties to look at developing a process in which compensation could be paid out pursuant to his order. And my friend from the Caring Society, I don't need to repeat her submissions, but pointed out the systemic processes that would be envisioned in developing that. And needless to say, throughout prolonged negotiations between Canada, the AFN, and the Caring Society, a compensation framework was developed, and it was approved by the tribunal. So really, essentially, that compensation framework really addresses the sheer scale of discrimination that is national in scope, and it calls for a well-organized process for individuals to obtain compensation. The AFN would argue the compensation order by the tribunal was clearly within its authority, given the social, political, and legal complexity of the situation, and the process to distribute compensation is best worked out through consultation and negotiations. And that's exactly what happened in this process. Now, the AFN would submit that Canada appears to be willfully blind to this reality and stating that class actions would achieve the better outcome. This may be Canada's preferred approach to address discriminatory conduct. However, it is not the only avenue. The AFN would point out one notable difference between pursuing this matter through the CHRT and the class action lies in control over the process. In a class action, like the Indian residential schools situation, parties have the power to negotiate a settlement that involves a lot of give and take. In this process, the tribunal has ordered compensation, and Canada has no control of this process. I can understand why Canada would appreciate or prefer a class action process, but that's not what we have here, and the tribunal did make an order that is binding. That's, of course, pursuant to this judicial review and subject to this judicial review. So lastly, on this point, the compensation framework is designed in a way that would allow those affected by discrimination to approve other court processes if they will, in fact, want to pursue personal harms. Again, the human rights regime deals with harms that are human rights based, loss of dignity or damage to one's dignity. It's open for individuals to opt out of this process and pursue their own proceeding or join class action to look at other forms of pain and suffering and damages, tort-like damage they may have suffered while in care. So at this point, I can break and then prepare to move on to some of the procedural fairness arguments of my friend Canada and a couple of residual issues.
Okay, just by my rough calculations, I think around 3:30 is what I think the time allotted. And as I said at the outset, I'm not holding everybody to things to the minute, but you've all talked about the times with one another, and the court accepts those time allotments. So we will break for 5 minutes, and we'll hear the rest of the APTN's arguments.
Thank you.
Perfect. The court is now in recess.
Recording stopped.
roll call just to make sure all council are available.
Absolutely, Your Honor. Council, if you can just confirm that you are back from break. Thank you.
Yes, the Assembly First Nation is back from break.
Canada is back from break too.
Amnesty International is here.
Caring Society is back from break.
Nan is present.
Human Rights Commission is here as well. Thank you.
Chiefs of Ontario is here. Microphone on. Thank you.
I think that's everybody.
Perfect. I confirm that everyone is here. I will prompt a recording.
Recording in progress.
The court is now resumed.
Okay, Mr. Wetke, the floor is still yours.
Thank you, Justice. So next, I'll move on. I was going to speak to procedural fairness, but I think that's been thoroughly canvassed and covered by my colleague, Mr. Dalgabo, and from the Caring Society. So I'll move on to Canada's argument regarding systemic versus individual relief. And in this vein, the Assembly First Nations would suggest that if you follow Canada's preferred avenue with respect to this, it would lead to absurd results, much like those described by the Caring Society. So yesterday, Canada asserted the tribunal did not have jurisdiction to award compensation because no child complainant was a party to the action and no child provided evidence for the assessment of damages. Canada relies on Moore to support this proposition that for complaints of systemic discrimination may only yield systemic remedies. In particular, that the tribunal may not award individual remedies such as individual compensation and systemic claims, according to the Attorney General of Canada. Now, it may appear that Canada may have abandoned this argument that one cannot have individual remedies in systemic cases. However, the statements made by my friend for Canada yesterday are difficult, I should say, are different from what's written in his submissions. In particular, paragraph 63 of the factum. So the AFN is somewhat uncertain to what Canada is really arguing on this point. Nevertheless, the AFN would submit the tribunal already addressed Canada's argument that systemic discrimination requires systemic remedies, which is true, but that this should not preclude individual compensation awards. In this regard, the tribunal stated at paragraph 142, in claiming that there's no evidence in their record to support compensation to individual victims who are not complainant in this case, the panel finds that Canada does not consider section 50 sub 3C of the Canadian Human Rights Act, which states subject to subsections 4 and 5, receive and accept any evidence and any other information, whether on oath or by affidavit or otherwise, that a member of the panel may see fit, whether or not evidence or information is or would be admissible in a court of law. The only limitation in relation to the evidence that is found at section 50 sub 4 of the Canadian Human Rights Act is that the member or a panel may not admit or accept evidence that anything would be admissible in a court by any reason by privilege under the law of evidence. At paragraph 144, the panel goes on to state that it is unquestionable to require vulnerable children to testify about the harms done to them as a result of systemic racial discrimination, especially when reliable hearsay evidence such as expert reports, reliable affidavits and testimonies of adults speaking on behalf of children and other government official documents support it. The AGC is making submission, the Attorney General of Canada in making submissions does not consider the tribunal's findings in 2016, accepting numerous findings in reliable reports as its own. The Attorney General omits to consider the tribunal's findings of children suffering in past and unchallenged decisions in this case. Now, the AFN would submit that the Canadian Human Rights Act principles and the need to provide a remedy that is effective in promoting the right being protected and meaningful vindicating rights and freedoms of the victim of discrimination is necessary. This was, and this is being compounded by Canada's awareness of the request of compensation for the special damages, participation on the issue of compensation, and ultimately the consultation protocol by the Minister Philpott, which addressed compensation. It really boils down to providing an effective remedy and the special nature of the Canadian Human Rights Tribunal based on the broad and liberal interpretation of requests for compensation included in the initial particulars and complaint. Compensation, the AFN would argue, is always an issue. Now, with respect to Moore does not restrict individual compensation. Rather, it purports to state that that a remedy must flow from the claim, which the tribunal gave effect here. The tribunal did recognize that we were seeking compensation from the outset. The AFN submits that the AGC's understanding of remedies in systemic cases is illogical at best. On its face, its position would deny any compensation for failure to accommodate a claimant's special needs, which arises from a systemic barrier due to membership in any protected group or human rights legislation. Every year, thousands of systemic human rights complaints across Canada allege, for example, that an employee may have lost pay because an employer failed to accommodate the employee's needs to just work hours or to accommodate childcare needs or doctor's appointments, those types of things. However, hours of work comprise part of the employment system. If discrimination is found and pay is awarded, the system is ordered to be changed. So Canada's reliance on Moore is also flawed because the case did not preclude individual remedies for systemic discrimination. Rather, the court held the remedy must flow from the claim. In the present case, Canada's Child and Family Services program discriminated against First Nation children in almost every community across Canada. These children were unnecessarily removed from their parents, families, and communities. Each one of these children suffered both collective harms and individual harms as a result of Canada's conduct. The Attorney General of Canada's position would effectively leave no room or form of compensation to the victims of discrimination where systemic problems persist. This would enable abusers of human rights and state actors who possess extraordinary power over others to escape any financial liability for their actions, harms, or misdeeds. This proposition is contrary to both domestic and international human rights standards. In systemic human rights actions, representative victims constitute the public face of all victims. Representatives can also focus on disturbing stories of individual victims. They can highlight the systemic nature of the wrongs, regardless of the case put forward by the representative claimants. Human rights law requires that victims of discrimination are valued as human beings. And this is what the AFN would submit has taken place in this case. Compensation for the violation of human rights is an essential, let me phrase that. Compensation for violation of human rights is essential to return injured individuals to the position they would have been not for the infringement. And that is a fundamental aspect of human rights law. It is also essential to ensure human rights law do not devolve into empty words. The AFN would submit that a human right whose violation has no consequences lack any real substance. Clearly, this is what not was intended by Parliament. Justice Laforêt referred to such an approach of rights without remedies as a thin and impoverished vision of equality rights. Any violation of human rights must yield effective consequences. So in that respect, the AFN completely disagrees with Canada and would submit that the reasons of the tribunal are adequately address this issue. Now, I'll move on to the next issue regarding the tribunal exercising its jurisdiction. And here the Attorney General of Canada alleges that the Tribunal's framing of the AFN and Caring Society's complaint was erroneous, as it was not entitled to transform a complaint of discriminatory underfunding into a complaint of seeking individual compensation. Effectively, Canada is claiming that neither the complaint or the evidence led to provide a basis for the Tribunal to provide individual compensation in this matter. Of course, the Assembly First Nations disagrees with that. The AFN submits that the AGC, Attorney General of Canada, has in fact mischaracterized the Supreme Court's reasoning and more, and is effectively attempting to establish that the approach to allegations of discrimination are taken by the Tribunal should have been accomplished in a binary way, either being individual or systemic. However, noted by the Supreme Court in Moore, it is, this is quoting Moore, neither necessary nor conceptually helpful to divide discrimination into these two discrete categories. A practice is discriminatory whether it has been an unjustifiable adverse impact on a single individual or systemically on several. The only difference is qualitative. That is, a number of people disadvantaged by the practice. Importantly, in Moore, the Supreme Court of Canada did not preclude systemic evidence as being a sufficient basis for the grounding of a finding of discrimination, which could elicit both systemic reform and individual compensation, such as the case of Canada's discriminatory provision of child and family services at the heart of this case. And that was explained in the merits decision and the compensation decision. For the Supreme Court in Moore, the crux of the matter was simply that the remedy must flow from the claim, as addressed in the systemic evidence presented therein, was merely presented as an additional evidence of the child at issue that was discriminated against. Again, this does not mean that a finding of discrimination predicated on the systemic evidence precludes an individual remedies, and in addition to systemic reforms. Now, Canada says this is sort of the flip side of the same coin. But as my friends pointed out in Moore, Moore dealt with an individual who was seeking a relief from his school board. He was denied special programming for his needs. Now, the tribunal at that case essentially awarded individual compensation to the young person, but also required the province to address this more broadly. And the courts found that in that circumstances where you have a single individual claiming discrimination that could be addressed by the service provider, the local service provider, it does not make sense to require wholesale changes within the whole provincial regime. That's quite the opposite of what's happening here. And we would disagree with Canada on this point. Canada sort of is saying that, well, if you take those that fact scenario, essentially, if you have systemic issues, you have systemic remedies. If you have individual issues, you get individual remedies such as compensation. And that clearly is not supported by Moore. And in this case, you have a large number of First Nations people in every First Nation community across Canada that's being discriminated by Canada's conduct. Clearly, systemic remedies are required in those cases, but individual harm is being done in those circumstances as well. So the AFN would argue that Moore does not stand for Canada's proposition, but essentially it would enable, a proper reading of the case would enable individual remedies as well as systemic remedies in cases of systemic discrimination. So as a remedy must flow from the claim, it is clear that the Attorney General of Canada has erred in her supposition that Moore demands that a victim must be identified with peculiarity, and that the said individual must provide evidence of the harm suffered because of discriminatory practice. The AFN would submit the Attorney General of Canada has provided no basis for these erroneous requirements, applying that peculiarity where heightened damages are sought is based on the party's conduct. The Attorney General relies on the Federal Court of Appeal decision in CNR, where they noted that the tribunal's remedy authority is limited to compensation to victims, which made it impossible in any event inappropriate to apply to a group or systemic discrimination, whereby virtual individual victims are not always readily identifiable. What the Attorney General Canada failed to address in this case is that the Federal Court of Appeal's decision was reversed by the Supreme Court, which restored the tribunal's order to CNR to adopt a special program which imposed a quota on female hiring until women were represented to be 13% of the workforce. By its very nature, the compensation order would benefit unnamed, decision in that case, I should say, would benefit unnamed and unparticularized non-female job applicants in the future. The Supreme Court made it very clear in CNR that the tribunal in the present case, as the tribunal in the present case recognized that human rights codes must be interpreted in a fair, large, and liberal manner to ensure that their important objects are attained. Now, the Assembly First Nations would submit in the current case, the powers of the tribunal must be encompassed with both individual compensation and systemic remedies, really to counter the full extent of the proven discrimination that was visited upon First Nation children and family, and to penetrate institutional barriers to change. And my colleague, Mr. Nawagaba, pointed out the tribunal's constant positions with respect to bureaucrats within Canada's bureaucracy falling to the old colonial mindset. It's those types of barriers that need to be addressed and penetrated to ensure that the full potential of First Nations children and also the ability to keep them in the home can be realized. So the Assembly First Nation would submit that the tribunal fully dealt with and reasonably dealt with Canada's claim of surprise with respect to the claim of compensation. Now, I won't go into that, but essentially we adopt the positions of my friends from the Caring Society on that regarding the statement of particulars. But we would note that as a note by the tribunal, the statement of particulars in this case constitutes an extricable component of the claim. It was designed to flesh out the scope of the claim, and since the claim form is short, it cannot truly reflect all the elements of the claim, especially complex ones. And as of all the parties to this process pointed out, this case is a very complex one. But at the very heart of the complaint, it really deals with First Nation children. And we also would note that the Assembly of the First Nations would submit that the tribunal also squarely addressed the Attorney General of Canada's assertion that individual compensation must be predicated on individual victims being party to the complaint before the tribunal, essentially leading substantial evidence on their proposals and their personal experiences. The tribunal acknowledged that in section 40-1 allows a group to advance a complaint if it has reasonable grounds to believe a person is engaging in discriminatory practice. And that's exactly what the Assembly of First Nations and the Caring Society did in this case. We wrote a claim, a systemic claim based on a whole large number of individual victims, but we were able to represent them. And the tribunal points out the AFN resolution. So essentially the way the Assembly First Nation operates, Assembly First Nations represents First Nation communities across Canada. All First Nations that are willing are members of the Assembly First Nation. We get mandates through resolutions that are passed by the chiefs and assemblies twice a year. One resolution in particular, Resolution 85 in 2018, sets out a mandate where the First Nations across Canada provided the AFN with a mandate to seek compensation on behalf of their members. And this is evidence in the resolution that was provided to the tribunal. The mandate provided that AFN was empowered to speak on behalf of First Nation children who are victims of Canada discrimination, including voicing the needs to redress for their harm suffered by way of compensation. The tribunal was clear that any beneficiaries of the decision would have the right to opt out of this compensation award. It is clear that the tribunal endorsed AFN's representative status in this matter and is relying on a highly credible witness. They also reference other highly credible references, such as the Truth and Reconciliation Commission or other adults who spoke on behalf of children in an effort to voice the harm and suffering endured by First Nation children and families. The tribunal relied on numerous findings of fact in relation to the harms visited upon by First Nations children that has made in its merits decision and its 10 subsequent decisions prior to compensation being awarded. These were in turn based on thousands of pages of evidence, including testimony, in transcripts, and reports. The tribunal also made it clear it was not purporting to reproduce all the evidence before it. Ultimately, the claim for the tribunal was and continues to remain throughout its proceedings about discrimination of First Nation children and families. It was never, despite the Attorney General of Canada's assertion, a moving target of a complaint which expanded over time. While Canada attempts to show that its funding model was not discriminatory, it was always aware of our compensation claim. Canada's characterization of the tribunal's case and management as an abdication of its responsibilities to issues clear, practical, and reviewable orders, and its allegation that the tribunal has transformed and expanded the complaint is an example of a party inappropriately searching for ways and means to minimize those rights and to enfeeble their proper impact. And the AFN submits this is what Canada is doing in this case. Indeed, the refusal of the tribunal to expand the scope of compensation order as requested by Nan and Koo indicates the tribunal is very careful with the scope and nature of the complaint. My friend from the Caring Society spoke about the decision where Nan and Koo tried to expand the compensation order to other individuals. But clearly the tribunal looked at the evidence before it and did not provide that relief. So the AFN would submit that the complexity of the complaint and the nature of human rights cases, reconciliation of Canada's continued efforts to undermine the terms of the merits decision all support the tribunal's continued jurisdiction over the matter and implementation of the ongoing processes. Now, so I have a couple more points to make. This morning, you asked my colleague from Caring Society about, yes, the question about Canada's statement that the provinces control apprehensions and that somehow that should have an impact, or whether it would have an impact. And the AFN would like to provide its thoughts on this. And again, we would turn to the tribunal's merits decisions. My colleague will pull those up. Now, while my colleagues pulling up the relevant passages of the merits decision, I mean, the AFN would submit that, contrary to Canada's assertion that the provinces really control child welfare, it is true that the provinces were the only legislative regime in Canada in force at the time. Of course, now there's the Federal First Nations Child and Family Services Act. But really at that time, it was the provincial regimes that applied. But the AFN would point out that the tribunal itself spoke to a number of issues with respect to this, and regarding Canada's control over the child welfare regime. I'm sorry, I didn't realize it's not even on my screen, so I'll pull that up. Just give me 1 second.
You go ahead. So we would draw your attention to paragraph 71 of the merits decision. And essentially, the tribunal found in its reasons that ANDCs, essentially the Government of Canada, plays a significant role in the effort to improve the outcomes of First Nation children and families residing on reserve. While ANDC argues that it does not control services, the manner and extent that the ANDC's funding significantly shapes child and family services provided to First Nation agencies and or the provinces or territories. At paragraph 73, it is AANDC that created the First Nation Child and Family Services Program and its corresponding funding formulas, and who negotiates and administers the provincial territorial agreements. AANDC holds a considerable degree of control in this regard. At paragraph 75, furthermore, AANDC has a power to withhold funds if CFS agency, First Nation Child and Family Services agencies and or the provinces/territories do not comply with its funding requirements. This will result in agencies closing their doors. As a consequence, inadequate child and family services being provided to First Nations and family on reserve in the Yukon. At paragraph 105, the First Nation Child and Family Service Program and other related provincial and territorial agreements were undertaken and controlled by the Crown. The Crown has discretionary control over the First Nation Child and Family Services Program through policy and other administrative directives. It also exercises discretionary control over the application of other related provincial territorial agreements, as First Nations are not party to these negotiations. In paragraph 106, the legal and substantial practical interests of First Nations children's families and communities stand to be adversely affected by AANDC's discretion and control over the First Nation Child and Family Services Program and other related provincial and territorial agreements. Now, what the AFN would like to highlight in this circumstances is that even though Canada merely argued it was a funder, it does have a large degree of control over the process. So regardless of what the provincial legislation says, and it's quite clear, provincial legislation at the time required all agencies, including First Nation Child and Family Service agencies, to provide least disruptive measures or prevention services. That funding was not there. Essentially, those aspects of the legislation could not be implemented by First Nation agencies. So in conclusion, the AFN suggests that this case deals with compensation for children removed from their families. A significant majority of children are brought into care as a result of neglect and poverty. Being taken from one's loving family and placing them in the care of strangers or boarding homes or hotels causes harm to both children and individuals. And the comment made by my friend Mr. Frater yesterday about a child spending 3 days in a friend's house, we at the AFN also agree with the Caring Society that that is clearly highly charged and potentially offensive a narrative to address a child being taken into care. And as my colleague from the Caring Society points out, that's not the standard practice. Children are not taken out of homes and placed with a family friend. Usually they're placed with strangers. But what's really clear and key in this case, these children are vulnerable, and it's important to note that a large majority of children are apprehended for neglect for First Nation children, a significant majority. These children are coming from loving, caring parents who, for whatever reason, have financial issues, maybe some substance abuse issues, or maybe overcrowding in the homes. These children are being taken from the protection and love of their parents, their families,
and placed outside of that protection in foster homes, sometimes hotels, or in group homes. And while we didn't really speak to it, and we would encourage Your Honor to look at the affidavit of Miriam Ellen Turpel that's included in the materials in the record. She really speaks to what happens to children when they're actually taken outside the home. And essentially the evidence provided by her while she was a child advocate of BC dealing with a number of issues and drafting a number of reports of the particular circumstances of children in care and the adversities they face. She points out that, you know, there is a higher risk of children, especially First Nation children, going into care, suffering from or becoming addicted to drugs and substance abuse. Of course, suicide levels go up. They're open to sexual abuse, sexual exploitation. They're open to human trafficking, especially in cases where they're put in hotels. There's mental distress. And there's a whole host of other issues that follow these children. And again, a lot of this is unnecessary removals. And you're dealing with children that come from loving parents who are just faced with poverty. And you're taking them out of that loving home where they're protected and putting them into this alien environment, much like residential schools, where the parents and the children have no control over what happens to them. And that is damaging. But that speaks to class action type of damages that's part of another process, but not necessarily human rights, which is why the tribunal really didn't develop on it. But it really does provide a good indication of what happens to a child once they leave their parents' home and placed into foster care. So in conclusion, the Assembly First Nation is requesting the following relief. The AFN respectfully requests that both the AGC's applications for judicial review be dismissed with cost and dismissed in their entirety. That is our preference. In the alternative, should this honorable court decide that there is any deficiency in the process or the reasons of the tribunal, the AFN would submit that the compensation decision should not be set aside, but rather affirmed, and that any deficiencies identified could be returned back to the panel with appropriate directions. So we are looking at an affirmation that the decision of the tribunal was reasonable. The AFN would submit that it would be highly inappropriate to remit this matter back to a differently constituted panel as requested by the Attorney General of Canada, because the current panel continues to hold jurisdiction over this matter, particularly in relation to the issue of compensation. Moreover, the panel in the course of the last 9 years or so, which has presided over the complaint, has accumulated knowledge and insights into the management of the complaint. And all of this would be lost if it was remitted to a different panel. This would be a waste of the tribunal resources, potentially harmful to the interests of First Nation children and families who would undoubtedly experience delay in seeking and obtaining justice. Subject to any further questions, those are the submissions of the Assembly First Nations.
Mr. Wetke, I think you've answered a lot of some of the questions that I had asked other people. So thank you for answering those. I noticed that we're a little bit ahead of schedule, and so Chiefs of Ontario, I'm pretty flexible with processes. Would you prefer to begin your submissions tomorrow or now?
Hi, Your Honor. Well, our submissions are brief, as you know.
Mm-hmm.
I actually thought that the commission was maybe going to go before us. I'm happy to do our submissions now if you want, because they're, as I say, they're quite brief. So I'm in your hands.
Yeah, in the letter with the general timetable had after the Assembly of First Nations, the Chiefs of Ontario.
Okay. I'm happy to go.
If you're okay, I don't mean to because the schedule was for tomorrow. But
no, I'm not interested in wasting the court's time, so I'm happy to proceed now.
Okay.
Okay.
Can I, sorry to intervene, can I intervene? It's Natasha for the Court Registrar. Mr. Favel, I would like to put as a chat for all panels and attendees the Indian Residential School Survival phone line on behalf of everyone, and also part of my recess share document. Once we are off camera, I just want to make sure that that would be granted and okay with you, sir, if I share that for any participant that may be affected or triggered by our conversation and discussion today.
Absolutely. That's a wonderful idea.
Okay, perfect. It's from the Assembly First Nation that reached out to me. I want to thank you, the Assembly First Nations, for that. I will post it now. Thank you.
Thank you. Ms. Wenty, we'll turn it over to you on behalf of the Chiefs of Ontario, and maybe if you need more time, we'll go. Maybe that'll be an appropriate time for us to conclude is after you.
That sounds great. Thank you, Justice Favel. So I'm Maggie Wenty. I'm counsel for Chiefs of Ontario, and I'm coming to you today from the traditional territory of the Mississaugas of the Credit First Nation, and I just wanted to acknowledge that. Chiefs of Ontario has been involved in this litigation as an interested party for many years now, and the primary purpose of Chiefs of Ontario's participation is to provide a perspective of the Ontario First Nations, because, as you know, the funding situation with respect to how First Nations Child and Family Services agencies in Ontario are funded is different in Ontario than it is in the rest of the country. Accordingly, we've been participating in order to provide our perspective and how the discrimination might operate differently or has operated differently with respect to Ontario because of the existence of the 1965 Indian Welfare Agreement. That said, with respect to the compensation issue, Chiefs of Ontario agrees wholeheartedly with the submissions of the Caring Society and the Assembly of First Nations. We don't see there being any Ontario-specific issues that we need to make submissions on at this point. So we have just come here to lend our support, but we do have submissions, as you know, with respect to the definition of First Nations children and the First Nations community recognition process. And so, I mean, as I said, I promised you I'd be brief, and I was, but we don't have anything else to add because our friends have so exhaustively covered the field, and so we support them. Thank you.
Thank you very much, Ms. Wenty. I don't have any questions. As you say, your brief speaks to matters, so I'll review it again, of course, when I'm deliberating. So thank you. With that, I think we'll break for the day, and unless there's a reason for Anishinaabe Ski Nation to push through, but you know, I think we've had a full day, and staring at the screens can be tiring. So I think under the circumstances, we'll break for the day. And I do want to thank the Assembly of First Nations for reaching out to the registrar to post the material. That's a very good suggestion. With that, we'll reconvene, we'll recess, and we'll reconvene at 9:30 tomorrow morning.
Well noted, sir. Thank you, Council. We will see you tomorrow for 9:30. The court is now adjourned for tomorrow.
Recording stopped.